She's taken merchandise. She's processed refunds that weren't hers and put them on the gift cards and try to sell the gift cards off later. Yeah.
Because I've never seen so much paperwork and so many transactions. These are her statements that she has written to you guys?
Yes, this is the statement that she wrote today.
I'm sorry, but yeah. We're talking about thousands of dollars of stuff. Did you not think that that was going to happen?
On October 27th, 2023, in Lake County, Florida, Officer Ketchum responded to a Belk department store where an employee had been caught in a months-long fraud scheme involving stolen merchandise, fraudulent returns, and gift card resales.
Are you going to take me to jail now?
Ma'am, I have to. I mean, we're going to go to my police department so I can do some paperwork first, but that's what we have to do.
I'll follow you.
No, it's not following me. You're going to be going with me. All right.
The reason why I called, so I have an associate in the office. Michelle Barton is our asset protection of one of our zones in the company. And
The person in question is an asset protection person?
No. She's an associate with us.
Oh, okay.
She's in the office on the phone with Michelle Barton, who is the asset protection for the East Zone in Belk, which is like one of three in the entire company.
Okay.
They've been doing an investigation on her with some stuff. This is for you. This is part of the investigation.
Good Lord.
Yeah. This is just records of the transactions that she did. She's taken merchandise. She's processed refunds that weren't hers and put them on the gift cards and try to sell the gift cards off later.
How long has this been going on? How much stuff are we talking?
She's admitted to at least starting in September to about $1,000, but according to Michelle, there's more than that. So, and then she would take the gift cards and then try to sell them. And she's admitting to try to sell the gift cards off.
Okay. Does she know I'm here?
She knows, yeah.
Okay.
Yeah, she knows that you're on your way. So,
okay. And how many transactions are there about? So when was this discovered?
It was just brought to my attention yesterday.
So all of this information was collected between yesterday and today?
This is not the information I've collected. This is information that Michelle's collected.
That's what I'm saying. How long has she been collecting information?
That would be a question for Michelle. We can ask her.
You don't know that?
I do not know that. That is, I was told yesterday
because it appears this has been an investigation that's been going on for a while.
Yeah.
Because I've never seen so much paperwork and so many transactions. This is going to take a little bit to go through.
Right. Yeah. These are her statements. These are.
Okay, so these are her statements that she has written to you guys?
Yes, this is the statement that she wrote today.
The store's corporate loss prevention team had already completed an internal investigation and handed the officer a full evidentiary package. What follows raises three distinct legal questions: Miranda timing, the admissibility of a pre-arrest written confession, and the legitimacy of dual felony charges.
I'm in financial problems, meeting monthly end. I did what I have to do the wrong way. Twink. I started taking stuffs. What? I took some clothing, tops, pants, and some jewelry, maybe about $1,500. $1,500. Right. Is that 500 to 800?
Yeah,
sorry.
yeah.
I did take return as gift card and cash returned. Not sure the exact amount. I sold them for cash to people. I need the money for bills and foods, which my salary didn't cover enough for the month. Could be more. I can't think. I'm guessing maybe $2,000 to $3,000, not more.
She's brought.
Oh, that's just a copy of the same thing.
Yeah, she's brought merchandise back to us
today.
Yeah, she she left and went and got merchandise that she had at her house, along with 3 gift cards and a $100 bill.
So you've recovered a few things.
Yes. Sorry.
Hello.
Doing the investigation.
I'm trying.
Yeah.
It's a lot to take in.
Hey, Michelle.
Hey, I'm going to disconnect. If you need me, just shoot me a message, okay?
Okay, we'll do.
Okay, thank you.
All right. Bye.
Oh, I thought we were coming up here to find out if she's got the video.
No, I'm gonna
Okay.
text her.
So this is not everything. This is just what she's found so far. Is that what we're talking?
Yeah, that's the stuff that Michelle and her team investigated and pulled.
So this is everything?
To the best, that's the stuff Michelle sent me. That's everything that that Michelle and their team identified as.
Okay. Is this stuff included in here?
No, this is stuff that Jenny brought in today.
So that's separate. That's not on here.
Right. I haven't matched these gift cards up to any of this.
Okay. So that's what I'm saying. So that's going to be separate from this stack.
Yes. The only thing that might be similar that we'd be able to identify from that versus here is these gift card numbers matching up with some of the gift cards on there.
Yeah, I'm not talking about gift card numbers. I'm talking about items. The different items. The
Yes.
items that are on here is not any of
Separate
this.
from this.
Okay,
Yes.
so it's going to be this plus that.
Yes.
Okay.
The suspect provided a detailed handwritten statement to her corporate employer before law enforcement ever arrived. Under the Supreme Court's ruling in Burdeau versus McDowell, evidence obtained by private parties is not subject to Fourth or Fifth Amendment exclusion. Belk's loss prevention team is not a state actor. Their investigation is not bound by Miranda. That statement is admissible. However, the circumstances under which it was obtained still carry legal weight at trial. The suspect was alone in an office, surrounded by management, on the phone with a regional asset protection supervisor, and fully aware that police were en route. Under Colorado versus Connelly, the voluntariness standard requires proof of governmental coercion, not merely personal compulsion. Because the statement was obtained by a private employer, not the state, a voluntariness challenge is unlikely to succeed, but a competent defense attorney will raise it.
Okay. Ma'am, my name is Officer Ketchum, okay? How do you pronounce your first name? Okay. So, from what I understand, Mr. Winter said that this is a statement that you wrote today?
Yes.
Okay. Now what I'm going to do, I'm not going to ask you any questions about the returns or what happened or what you did. I just need to read you Miranda because we're in a situation that involves an arrest, okay? All right? Man, I'm sorry, but yeah. We're talking about thousands of dollars of stuff. Did you not think that was going to happen? Okay. So I'm going to read you Miranda, but I'm not going to ask you any questions about the thing. I'm just going to ask you if this is the statement that you wrote. Okay? So I'm just going to read it off the card. If you don't understand something, let me know, and I will explain it to you, okay? All right. You have the right to remain silent. Anything you say can and will be used against you in the court of law. All right? You have the right to an attorney, and you have the right to have that attorney present with you during questioning. Okay? If you don't want to or you choose to, after or during any questioning, you can stop speaking at any point in time. Okay? Now, do you understand everything that I've explained to you? Okay. Now, having those rights in mind, do you wish to speak to me? Okay, because like I said, the only thing I'm going to ask you is this right here.
Yes.
Is this the statement that you provided to Belk?
That's what. Yeah.
You wrote this yourself. Nobody wrote it for you?
No.
And no one coerced you or made any threats to you
No.
to write this statement?
No.
And this is a true, accurate depiction of what you state happens?
Yes.
Okay. That's all I'm going to ask you, okay?
Officer Ketchum administered Miranda warnings approximately 6 minutes into his encounter with the suspect after reviewing the evidence file, but before any direct questioning. The central Miranda question here is not whether warnings were given, but whether the pre-warning conversation constituted custodial interrogation. Under Berkemer versus McCarty, custody is defined by whether a reasonable person in the suspect's position would feel free to leave. Inside a store office, with police on scene reviewing evidence against her, the suspect was effectively in custody from the moment Officer Ketchum arrived. The officer's decision to limit pre-Miranda conversation to reviewing documentary evidence, not questioning the suspect directly, is what saved this arrest procedurally. He explicitly told her he would not ask about the returns or what happened. That restraint is legally significant. After Miranda was administered, the officer asked one question: is this the statement you wrote, written voluntarily, without coercion? Under Rhode Island versus Innis, that is, express custodial interrogation, it is designed to elicit an incriminating response. However, because Miranda warnings had already been delivered and the suspect acknowledged understanding her rights, that authentication question is legally sound. The suspect faces two separate felony charges: grand theft under Florida Statute Section 812-014 and organized scheme to defraud under Section 812-035. These are not duplicative charges. They address distinct criminal elements and require separate proof. Grand theft addresses the taking of specific property. Scheme to defraud addresses the ongoing systematic course of conduct across multiple transactions and multiple days. Florida courts have consistently upheld dual convictions where theft and scheme to defraud arise from the same underlying conduct. The loss amount determines the felony degree for each charge. The suspect's own written statement estimated $2,000 to $3,000, but corporate transaction records document a figure exceeding $5,000. The prosecution will rely on the corporate figure. At $5,000 or above but below $20,000, both charges are classified as third-degree felonies under Florida law, each carrying a maximum of 5 years.
Is there anybody that you need to call to let them know what's happening?
That's my husband.
I'm sorry?
My husband.
Well, that's what I'm saying. Do you need to call him to let him know what's happening and what's going on and where you're going to be?
Are you going to take me to jail now?
Ma'am, I have to. I mean, we're going to go to my police department so I can do some paperwork first, but that's what we have to do.
Oh, yeah, I'll follow you.
No, it's not following me. You're going to be going with me. Okay? But I'm giving you the option. You're being cooperative, and I'm always cooperative with people as long as they're cooperative with me. I'm giving you the option to call your husband and let him know what's going on so that he doesn't think something's wrong when you don't come home.
Okay.
Okay? I believe, I will have to double check, but I think your bond is going to be $2,000. Okay? So if you go through, are you familiar with the bond?
I know I've been arrested before, so I don't.
Okay, and that's fine. I'll be gentle. All right? A bond is money that you put up in order to get out of jail. Now, you can either put up the whole bond in cash, or you can go through a bail bondsman and only pay about 10 to 20% of that bond. Okay, but then that bail bondsman is the one that's responsible for you to go into court when the court series of this comes around. Okay, so if you don't have the $2,000 for the bond, then it's going to be more than that because we're going to scheme to defraud. It may be upwards of $10,000. I'm not sure. I'll be able to let you know as soon as I can. Okay. But once we get to the police station, I'm going to be doing my paperwork, and then I will take you over to the Lake County Jail. It's probably going to be a couple hours, okay? Because there's a lot of stuff here I got to go through, okay? So go ahead and call your husband, let him know what's going on, and when you get to the jail, once I've completed all my paperwork and I transport you over there, they will allow you to use the phone again. Then you can contact your husband again and make arrangements for that bond, okay, for the bail so you can get out. Okay?
Hey. I'm at work right now at the office. So later on you be buying me out of jail.
Like 23.
Yeah, we got taking stuff from there and stealing.
24 North US Highway 27 441. By the homeless subject since well over 2 hours been asked to leave and stop begging for money and he's refused to. By
I do
mail.
all the paperwork.
I'll let you call him again when we're getting ready to go over to the jail. As long as you're cooperative with me, I'll let you call him and then you
Okay.
before we go, so he knows when you're going.
All right.
Okay?
Okay. All right.
Because then that way I'll be able to give you the exact bond as well.
Thank you,
Okay.
sir.
I'll put these in the Okay.
No. Do you have to? I just walk for you in the car.
No, ma'am, I have to do this. It's policy. If you're under arrest, you have to be in handcuffs. Like I said, I'll put them in the front. That way they're not in behind you. Do you have a jacket or something or a shirt? No? Okay. You just want to turn them sideways that way. Okay. Your charges are going to be theft by fraud. Okay, you understand what that is? With all the returns and the money, whether it be cash or gift card, that's a fraud. You're also going to be charged with scheme to defraud because you did this on different days, different times. So we have multiple different offenses. You understand what I'm saying? It happened over, it looks like you're since September time, somewhere about a month or so. I'm just going to take a photo of this stuff here spread out again, since I got something to take a photo of. Now, was the $100, did you put that on that total as well? Okay. Is all this stuff included with it?
Yes.
Yeah, I don't need the cards, so I'll just get that. I'm going to double check and make sure we don't have anything illegal in here. I'm not saying that you do, but I have to check just because it's my job, okay? No pocket knives or anything?
No.
Okay.
That's my name tag.
You need that?
She can hold on to it.
She can hold on to that, okay.
Officer Ketchum receives a B+. He established probable cause before making an arrest decision, administered Miranda from a card to ensure accuracy, and confined post-Miranda questioning to statement authentication only. His transparency regarding the bond process, charges, and transport procedure reflects professional conduct that is uncommon in routine arrest situations. The deduction from an A comes from 2 points. First, Miranda was administered mid-encounter rather than upon first contact. A more conservative approach would eliminate any ambiguity about custody. Second, the officer's remark, "Did you not think that was going to happen?" while brief, crosses into editorializing that has no place in a professional arrest. The suspect receives a C+. Her cooperation during the arrest, no resistance, no flight, no hostility, almost certainly influenced the court's decision to impose probation, rather than a custodial sentence. However, her decisions in the weeks and months prior created a prosecutorial case that left her virtually no room to contest the charges. Providing a written confession to her employer without first consulting an attorney was the single most consequential legal error in this entire footage. Returning to the store on the day of the arrest with stolen merchandise, gift cards, and cash converted a potential defense argument into additional physical evidence against her. Belk Asset Protection receives an A-. The corporate investigation was methodical transaction records documented, pattern of conduct established, written statement obtained, and a complete evidentiary package handed to law enforcement. That documentation directly supported the scheme to defraud charge, which requires proof of systematic, ongoing conduct, not a single isolated act. The A- reflects one open question: whether the conditions under which the written statement was obtained will be scrutinized for coercive circumstances at trial. 3 lessons emerge from this case. First, never provide a written statement to an employer before speaking with an attorney. The private party doctrine means your employer can hand that statement directly to police, and they will. Second, returning stolen property does not undo a completed theft. Under Florida law, the crime was consummated the moment the property was taken. Voluntary return is mitigation, not a defense. Third, for law enforcement, the safest Miranda practice is to administer warnings upon first custodial contact, not after evidence review, not after preliminary conversation. The line between pre-arrest investigation and custodial interrogation is often invisible in practice and litigated aggressively in court. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.